Let's start then. Hello everyone, my name is Anurag Singh and I'm a teacher at the Pahuja Law Academy in Mukherjee Nagar area of Delhi. And if I have already taken, I think, 2 or 3 classes in your university, the North Cap University. So today I've been asked to give you an overview of the step-by-step procedure for the civil suits, right? The civil suits जो होते हैं, how do they actually function? Life of a civil suit, revisiting CPC essentials from filing of a suit to the passing of a decree, right? So फाइलिंग ऑफ द सूट से लेकर के पासिंग ऑफ द डिक्री तक का जो स्टेप बाय स्टेप पूरा होता है, वी हैव टू डिस्कस दैट. सो बट बिफोर वी गेट इनटू दैट, बिकॉज राहुल पानी के लिए बोल देना, ठीक है. बिफोर वी गेट इनटू दैट, फर्स्ट यू नीड टू अंडरस्टैंड द इंपॉर्टेंस ऑफ सीपीसी, राइट? कि व्हाई डू यू नीड दैट. जो तुम्हारा करंट टॉपिक है उसके पहले हम लोग को एक चीज डिस्कस करनी होगी, to understand really why do we need to understand the topic that we are covering in today's lecture. देखो CPC की importance में, देखो first thing, laws are mainly divided into 2 categories, that is criminal and civil, right? So in criminal law we study subjects like IPC and CRPC, right? That is it, the subjects that we have to cover mainly they are IPC and CRPC. Almost every other subjects that we study, they fall under the civil law, right? It can be contract, or it can be the Transfer of Property Act, or it can be Hindu laws, or it can be Muslim laws, or it can be company law, or it can be labor law, or it can be tort, or it can be partnership, or it can be the Sale of Goods Act, or many other acts like this. Limitation, registration, सारे के सारे हमारे क्या होते हैं? They are all civil law. So the point here that I am trying to make is that civil is much more broader than criminal, right? Criminal में the subject that we have to study, they are confined to IPC and CRPC, right? You don't need any other act, but for almost every other subject we have to study that will fall under the civil category. So it is not an exaggeration to say that 90% of the laws fall under the civil category, right? And to regulate these 90% of the laws, there is only one code, which is the CPC, right? So immediately, from an understanding point of view, you can see that CPC becomes a very important subject for you to study, right? और यहाँ पर to understand law, we can say that to understand law, you must be thorough with the CPC, because CPC regulates 90% of the laws, as simple as that. But एक बात और याद रखना यहाँ पर कि not only this, but also in the judicial services examination, you will be getting questions from CPC mains में. There will be separate paper of procedural law, and in that you will be getting questions from CPC, CRPC and evidence. So you can see 1/3 weightage is still given to the CPC, but that is not our concern here, right? अब देखो, CPC is a very important subject. Now, how do you study CPC? To study CPC, and the topic for today's lecture is that we have to start with the plaint and end with a decree. That is what I have been told, that I have to give you the life, what is the life of a civil suit, right? So that question, it can also be written this way, that how does an ordinary suit run, right? Or what is the life cycle of a civil suit? Life of a civil suit, right? So first thing, it starts with a plaint and it ends with a decree, right? Although this is said, but not strictly true, right? ऐसा कहते हैं कि plaint से start होता है और decree पे end होता है, but not really true, because there are other things also. देखो, first thing, a suit starts by the presentation of a plaint. That is section 26(1) of the Civil Procedure Code, which starts with the saying with that a suit starts with the presentation of a plaint, right? Now, when the suit has been instituted, then the second step is summons, right? जब plaintiff अपना काम कर दिया, उसने अपनी written submission को कर दी है, then second हमारा होता है कि defendant के ऊपर summons serve होते हैं. Then the defendant has to appear and file his written statement, right? The written statement is the reply to the allegations made in the plaint. The defendant actually files this one, and this is actually a reply to all the points that have been raised in the plaint. When both parties, the plaintiff and the defendant, they have given their written submissions, the next step is appearance and examination. Appearance and examination. And this examination is actually an oral examination, right? देखो, जब दोनों पार्टीज अपने written submissions कर देती हैं, the court asks both the parties to appear before the court and conduct an oral examination, right? And this examination, देखो, appearance का purpose है oral examination, and oral examination cannot happen without the appearance of the parties, ठीक है? Then यहाँ पर जब oral examination भी हो गया है, the next step होता है हमारा framing of issues or settlement of issues. Next step is framing of issues or also known as the settlement of issues, ठीक है? Then framing of issues के बाद जब issues frame कर लिए गए हैं, then next step हमारा होता है, next step is trial or the hearing, right? After the framing of issue, the trial starts और वहां से फिर हमारी hearing start होती है. And in the trial, there is an trial के end में there will be a judgment and a decree passed, right? Judgment will be followed by the decree. पहले judgment pass होगी, then the decree will be coming in place. So this is basically the life of a civil suit, or how does an ordinary suit run. This is it, ठीक है? अब देखो यहाँ पर, although कि our topic is to end to decree, plaint to decree, but याद रखना कि this is not where the suit ends. We would like to think so, but ऐसे actually end नहीं करता है, because after the passing of the decree, there are two courses of actions possible. The winning party would like to go for execution of the decree, जो implement कराना चाहेगा. So that party would like to go for execution, and the other party, or generally the losing party, would like to go for appeal, or it can also go for review or even revision depending upon the nature of the decree. Dinesh, एक चाय भी दे देना मुझे, ठीक है? So this is the complete timeline, or the basic timeline on which an ordinary suit runs, right? So it will start with the filing of the plaint, and after the plaint has been filed, a summons will be served upon the defendant, and then a written statement will be filed by the defendant, and then the court will ask both the parties to appear and examine them orally. After the court has examined them, the court will frame the issues, and the issues will be then put to trial, right? At the end of the trial, there will be a judgment, and the judgment will be followed by a decree. And after the decree has been passed, there are two courses of actions possible. The first is execution, which is actually the implementation of the decree, and the second one is there will be the appeal, or it can also be a review or a revision. That depends upon the nature of the decree. And appeal, review and revision are generally filed by the party who has lost the case. जिसे हम लोग कहते हैं, the party has lost the case, that party files the appeal, revision or review, right? Just to give you an overview. Now, what we are going to do, we are going to take each of these steps, ठीक है? इस लेक्चर में हम लोग क्या करेंगे? We are going to take each of these steps, और हम लोग इसे डिस्कस करेंगे कि ये स्टेप बाय स्टेप. अभी तो हम लोगों ने एक टाइमलाइन पूरी देख ली है, राइट? व्हाट वी हैव डन इज लुक एट द टाइमलाइन. अब हम लोग एक एक स्टेप को देख करके एंड विल गो इनटू द जस्ट द इंट्रोडक्शन पार्ट. मतलब पूरा तो हम लोग नहीं कर सकते, बिकॉज प्लेंट इटसेल्फ इज अ बिग टॉपिक एंड इट विल टेक लाइक 2 or 3 लेक्चर्स. तो आई विल जस्ट गिव यू एन ओवरव्यू कि प्लेंट में हम लोग को क्या चीज चाहिए होती है, समन्स में कैसा होता है, रिटन स्टेटमेंट में क्या होता है, अपीयरेंस एंड एग्जामिनेशन में क्या होता है, फ्रेमिंग ऑफ इश्यूज में क्या होता है. तो ऑल ऑफ दीज थिंग्स हम लोग को देखनी है, ठीक है? तो लेट्स स्टार्ट विद द नंबर 1, व्हिच इज प्लेंट, ठीक है? तो लेट्स लुक एट प्लेंट सबसे पहले. नाउ फर्स्ट थिंग अबाउट प्लेंट is that plaint has not been defined in the CPC. ठीक है? Since plaint has not been defined in the CPC, there is no one precise definition of a plaint, and that is why it is sometimes it becomes very tough to define, because की plaint क्या होती है. It has been defined by judges and authors and academicians, but there is no one precise definition of plaint because the CPC does not define a plaint, right? But if you are asked the question कि okay plaint में क्या क्या होना चाहिए, what should be the contents of the plaint, right? Contents of the plaint में देखो जब भी ये क्वेश्चन आए एंड जब भी हम लोग बात करें प्लेंट की, एनी प्लेंट इज डिवाइडेड इनटू थ्री कैटेगरीज, सॉरी थ्री पार्ट्स, नॉट कैटेगरीज, थ्री पार्ट्स, ठीक है. द फर्स्ट पार्ट इज द फैक्ट्स ऑफ द केस, ठीक है. द फर्स्ट पार्ट इज द फैक्ट्स ऑफ द केस. द फैक्ट्स ऑफ द केस लाइक, जैसे देखो सबसे पहले होगा नेम एंड डिस्क्रिप्शन ऑफ पार्टीज, राइट. अब देखो इसमें क्या होगा, नेम ऑफ द प्लेंटिव, लाइक द प्लेंटिव का नाम होगा, फिर सन ऑफ, डॉटर ऑफ, एंड देन उसका डिस्क्रिप्शन, देयर एड्रेस, ऑल विल बी देयर. देन देयर विल बी द नेम ऑफ द डिफेंडेंट, उसका सन ऑफ, डॉटर ऑफ, एंड देन देयर डिस्क्रिप्शन एंड देयर एड्रेस, राइट. And these 2 points will cover the name and description of the parties, right. The second point is going to be, if there is any property involved, you also have to describe the property. So description of property must also be there, right. Now description of property, let's say the property is a house, right. How do you describe a house, right. Whenever I have asked this question, the most obvious answer that people try to give is, they try to give me the area or the measurement of the house, कि सर इतना लंबा है, इतना चौड़ा है, which is not wrong. ऐसा नहीं है कि something wrong is there, but you don't need to give the measurement of the house. What you need to do is to give the location of the house, कि घर की location कहाँ पर है. And for that we would need information like house number or plot number, flat number or floor number. Even if you have heard about khasra number, right, khasra number is also going to be there, which is deemed as enough information to identify the location of the property, right. And not only this, मतलब ये सारी चीजें information तो रहेंगी वहां पर, house number, plot number, flat number. You also need and because some high courts have made these rules, that you also need to tell the code about कि इस property के north में क्या है, इस property के south में क्या है, इस property के east में क्या है, and इस property के west में क्या है. So all that information must be there if you are describing the property. I just give you one example of that is a house description of property. Now next is the cause of action. Okay, cause of action. Now cause of action is basically the reason of the filing of the suit. What is cause of action? Cause of action is basically the reason for the filing of the suit. You don't need to confuse cause of action with issues, because that is a mistake I have seen most people make. Whenever I ask this question ki what do you mean by cause of action, the first response they have is issue, right. सर इशू होता है, नहीं इशू नहीं होता, इशू तो फ्रेम करना कोर्ट का काम है. The cause of action is given by the plaintiff in his plaint. The court does not give you the cause of action, the court does not frame the cause of action. Court will look for the cause of action, yes, because that can be a ground for rejection of plaint, but the cause of action is the grievance of the plaintiff. What went wrong with the plaintiff? ऐसा क्या हुआ था कि उसे suit file करना पड़ा? So cause of action is basically the reason for the filing of the suit. Okay. Now this is the first part, right? Facts of the case. The second part is technical pleadings. Technical pleadings like limitation or jurisdiction or valuation, right. Now suppose you have the whole of the story, the facts of the case are okay, there is no problem in that, but suppose the suit is outside the limitation period, because you have to file the suit within a time limit, right. You cannot keep your cause of action alive for eternity, nahi, आपको एक particular time period के अंदर you have to file the suit. So you have to give a pleading to show that the suit is within the limitation period. And suppose the suit is outside the limitation period, the court is simply going to say that the suit is not maintainable and it can reject the plaint then and there, right. ऐसा भी हो सकता है. So same is the case with jurisdiction. अगर मान लो कि limitation में भी है suit, but the jurisdiction, like every court has a jurisdiction. Suppose the suit was to be filed in Lucknow court, but we are trying to file it in Bhopal court. So Bhopal court is going to say I don't have jurisdiction in this case. And that is why the technical pleadings should relate to the maintainability of the suit. Maintainability of the suit. ठीक है. Now, याद रखना, technical pleadings like limitation, jurisdiction and valuation, they are related to the maintainability of the suit. And at the end of the suit, or the final part of the plaint, the person asks for the relief, which is in the form of a prayer. If you have ever gone through the internship, in the internship you can see at the end, अगर आप plaint पढ़ोगे तो end में prayer clause होता है, right? And prayer is actually the remedy that you seek from the court. ठीक है. अब देखो, just give me a minute. So this is what a plaint would look like, and you can always divide a plaint into 3 parts, right? First thing is this. Now, this is the first part, or the first step towards the filing of the suit, right? The second step is the serving of the summons, or the service of the summons. So let's look at the next step. Second step is summons. Second step is summons. Okay. You know, CPC also does not define summons कि what is a summons. So summons को generally हम लोग ऐसे define कर सकते हैं कि summons is actually a intimation sent to the party, to one of the parties or both parties, that you have a hearing in the court, that the hearing of the court is being conducted and you have to appear. You have the right to appear before the court, right? So summons is actually the fulfillment of the principles of natural justice. If you have heard about the principles of natural justice, one of the principles is odi alteram partem, or the other side must be heard. But it's not so that the other side must be heard, but the language that should be used is the other side must be given an opportunity of being heard, right? So wo opportunity, how do you ensure that opportunity? You ensure that opportunity by serving the summons, or serving a kind of intimation to the party that you have a right to appear before the court when the suit is called on for hearing, right? Now, summons. That would be a basic understanding of summons. Ki it's an intimation by the court, and the reason for the service of summons is the fulfillment of principles of natural justice. Now, देखो summons में how do you serve summons? देखो पहली बात ये जानना कि summons के साथ always there is a copy of plaint attached. Whenever the summons are served upon the defendant, there is a copy of plaint attached. If you have the Bail Act of CPC, it is in under Order 5 Rule 2. Order 5 Rule 2 says the copy of the plaint must be attached with the summons, right? So that is why we can say कि plaint के बाद हमारा क्या आएगा? Summons आएगा, right? Now, how do you serve summons upon someone? ठीक है? There are many ways of service of summons. जैसे पहला हमारा है, देखो, service by court. Service by court. Here the court serves the summons. This is Rule 9. This is summons is in Order 5. And this is in Rule 9. Plaint में मैंने लिखा था या नहीं? Plaint is in Order 7. I'm sorry, ये मुझे बताना चाहिए था. Order 7 में है. Summons is in Order 5, and then there is the first thing is the service by the court. Now the court can serve summons upon many things, like it can serve a copy of summons by the process server of the court. Court का अपना process server होता है. It can also do by any courier agency, or it can also do by registered post acknowledgement due, that is known as RPAD. It can also be done by email or even WhatsApp, but there is a condition that the High Court has made the rules for it. ठीक है? So email, WhatsApp से, even fax से भी हो सकता है. यहाँ पर you can also write fax. But all of these things, email, WhatsApp and fax, they are only deemed as service when the High Court has made rules for it. ठीक है? Now, so this is the service by the court. Now, after that, there is the service by plaintiff, right? And this is in Rule 9A. ठीक है? अब देखो, एक बात याद रखना, it's a double-edged sword although, but फिर भी plaintiff is the best person to find the defendant. कि वो defendant कहाँ मिलेगा? And in most cases, it is the plaintiff who knows कि defendant कहाँ मिलेगा. So The court does agree with this, the law does agree with this, the plaintiff is the best person, but it's a double edged sword. मैंने ऐसा बोला था क्योंकि ऐसा भी हो सकता हो कि प्लेंटिफ सर्व करने जाए समन्स और सर्व ही ना करे, ना दिखाए उसे, और बोले कि कोर्ट को बोल दे कि मैंने समन्स सर्व कर दिया था, और कोर्ट जो है एक्स पार्टी डिक्री वहां पर पास कर सकती है. तो दैट इज वाई याद रखना कि ऐसा नहीं होगा कि सिर्फ सर्विस बाय प्लेंटिफ होगा, सर्विस बाय कोर्ट तो होगा ही होगा, सर्विस बाय प्लेंटिफ भी अलग से होगा, और इसे हम लोग कहते हैं, दिस इज नोन एज दस्ती समन्स. ठीक है, दस्ती समन्स. नाउ दस्ती, the word it's of Persian origin which means by hand, right? दस्ती का मतलब होता है by hand. तो plaintiff serves the summons by hand. तो अब ये देखो कि ये दोनों हम लोग ये जो देखते हैं सर्विस बाय कोर्ट एंड द सर्विस बाय द प्लेंटिफ. ठीक है, नाउ अब देखो ये दो पार्ट जो होता है कि हु सर्व्स, द कोर्ट कैन सर्व और द इट कैन द प्लेंटिफ कैन सर्व. द कोर्ट कैन आल्सो टेक द हेल्प ऑफ, इसी साथ कुरियर एजेंसीज का वो ले सकती है, हेल्प ले सकती हो. नाउ द अदर पार्ट इज on whom it is served, on whom it is served, right? किस पर सर्व करना है. now the person upon whom it is served, it can also be divided into three categories. The personal service, that is the defendant के ऊपर personal service, और the second one is extended service. extended service का मतलब आपके किसी फैमिली मेंबर पे, किसी एडल्ट फैमिली मेंबर पे सर्विस की जा सकती है. the third is the जिसे हम लोग कहते हैं चस्पा कर देना. व्हाट इफ द डिफेंडेंट कैन नॉट बी फाउंड, इफ हिज फैमिली कैन नॉट बी फाउंड, व्हाट यू डू, यू फिक्स अ कॉपी ऑफ द समन्स ऑन द बिल्डिंग और द रेजिडेंट ऑफ द डिफेंडेंट. उसके घर पे आप बाहर चिपका सकते हो, इट इज नोन एज चस्पा, राइट? एंड देन अगर ये सब कुछ ना हो, पर्सनली भी नहीं हुआ, फैमिली में भी नहीं हुआ, और घर भी नहीं मिला, राइट, ऑल ऑफ देम आर नॉट वर्किंग, देन यू गो फॉर दैट इज नोन एज सब्स्टिट्यूटेड सर्विस, एंड इज एक्चुअली a publication in a newspaper, and then there is also copy of summons on the courthouse. courthouse के बाहर जो नोटिस होता है आपके उस पर भी लगा सकते हैं. तो on whom it is served, इसके लिए मैं नेक्स्ट स्लाइड पे जा रहा हूं. on whom it is served, right? तो इसको भी हम लोग 4 पार्ट्स में डिवाइड करेंगे. फर्स्ट, on the defendant personally, right? फर्स्ट थिंग. दूसरा, अगर डिफेंडेंट नहीं मिलता है तो on his family member. Family member must be 18 plus. He should be an adult. अगर आपने उसके पर्सनली कर दिया, दिस इज नोन एज पर्सनल सर्विस. पर्सनल सर्विस, दिस इज नोन एज एक्सटेंडेड सर्विस. देन यू हैव, अगर उधर नहीं मिलता, देन on his residence, residential house, समझो, right? This is known as, in Hindi it is known as chaspa, or in English known as affixation, affixation of copy of summons. And then lastly we have the newspaper advertisement in the newspapers. Okay, this is known as substituted service. Substituted service, right? So these are the methods or the means by which a summons can be served. The personal service, this is rule 12, 13 and 14. Then we have extended service under rule 15. Then on his residential address, this is rule 16 and 18. And then we have substitute service under rule 20. Okay, so these are the ways by which different kinds of summons or different kinds of service of summons is effected, right? चलो नेक्स्ट, अब ये हो गया हमारा सेकेंड स्टेप. दिस वाज आवर सेकेंड स्टेप. फर्स्ट स्टेप हो गया हमारा प्लेंट, सेकेंड स्टेप हो गया हमारा समन्स. नाउ थर्ड स्टेप वी हैव रिटन स्टेटमेंट, राइट? चलो देखते हैं व्हाट डू यू मीन बाय रिटन स्टेटमेंट. देखो, so this is our third step and this is the written statement. देखो, written statement is basically a reply filed by the defendant. It is a reply to the allegations made in the plaint. This is in ऑर्डर 8, राइट, रिटन स्टेटमेंट इज इन अंडर ऑर्डर 8. अब देखो, ऑल्दो ये हम लोग सिंपल एक्सप्रेशन यूज करते हैं दैट रिटन स्टेटमेंट इज एन is a reply to the allegations made in the plaint, but मतलब although this part is true but not complete, right, इसमें क्योंकि इसमें और भी चीजें आती हैं जो कि हम लोग वहां पर मेंशन नहीं कर रहे हैं. देखो, रिटन स्टेटमेंट में फर्स्ट पार्ट इज द रिप्लाई टू द एलिगेशंस मेड इन द प्लेंट, राइट. अब रिप्लाई, देखो रिप्लाई भी हम लोग जो है वो रिप्लाई को भी हम लोग तीन तरीके से करते हैं. रिप्लाई में the defendant may admit the allegations made in the plaint, or he may deny the allegations made in the plaint, or he may also choose to remain silent. ठीक है, राइट. देखो, साइलेंस इज ऑल्सो डीम्ड एडमिशन. ठीक है, याद रखना इसे. when we say it is the written statement is a reply to the allegations made in the plaint, the reply does not need to be denial, although in most cases it is going to be denial, but there are also admissions, right. So reply can be an admission, the reply can be a denial, and the reply can also be silence where the defendant does not reply to an allegation. That silence is deemed as admission under CPC. Order 8 Rule 5 जब हम लोग पढ़ते हैं वहां पर जब evasive reply आप करते हो या फिर you make no reply, it is deemed as admission. ठीक है. Now, although कि ये पार्ट हम लोग रिटन स्टेटमेंट के बारे में समझते हैं, but याद रखना कि this is not the entire written statement, because the written statement may also consist of new grounds or new points. जैसे first is set off or counterclaim, or the third is others, right. So देखो, new points का मतलब, what do you mean by the new points? New points का मतलब those points which were not raised in the plaint. The plaint did not mention any of those points, but this is the first time that the defendant is mentioning them in the written statement. ठीक है, these are new points: set off, counterclaim, and others. Now in others, यहाँ पर क्या होगा? जैसे देखो, things like res judicata or things like res sub judice. Not only this, it can also be order 2 rule 2, or it can be order 23 rule 3, or it can also be order 22 rule 9, etc. देखो, all of these things, res judicata, res sub judice, order 2 rule 2, order 23 rule 3, order 22 rule 9, all of them, what do they say? They say कि this suit is barred. तो others जो वाला point है, एक्चुअली वो किस पे आता है? मान लो कि प्लेंटिफ ने कहा है द सूट इज विद इन द लिमिटेशन पीरियड, बट द डिफेंडेंट इज सेइंग नो, द सूट इज नॉट विद इन द लिमिटेशन पीरियड, राइट. इट कैन बी अ डिनायल, बट सिंस इट इज अ न्यू पॉइंट, वो यहाँ पर एक्चुअली फॉलो करता है. ठीक है, इट कैन ऑल्सो बी अ डिनायल, ऑल्दो if it is a mixed question of law and fact, then it becomes in this point, वरना it's a denial. ठीक है, ध्यान देना कि न्यू पॉइंट्स कौन कौन से होते हैं? सेट ऑफ, काउंटर क्लेम एंड अदर्स. अदर्स में मेनली लाइक, तो अदर्स वाले जो पॉइंट है वो एक्चुअली ये बताते हैं कि दिस सूट इज नॉट मेंटेनेबल, राइट. वो ये बोलते हैं कि दिस सूट इज नॉट मेंटेनेबल. जैसे रेस जुडिकेटा का वो प्ली लेता है, बोलता है कि दिस सूट इज नॉट मेंटेनेबल. रेस सब जुडिस में भी ये बोलता है कि दिस सूट शुड नॉट बी प्रोसीडेड विद. नॉट मेंटेनेबल ऐसा नहीं बोलेगा, नॉट प्रोसीडेड विद बोलेगा. ऑर्डर 2 रूल 2 नॉट मेंटेनेबल, अगेन ऑर्डर 23 रूल 3 नॉट मेंटेनेबल, ऑर्डर 22 रूल 9 नॉट मेंटेनेबल. अदर्स वाले पार्ट में हम लोग वो प्लीडिंग्स डालते हैं जो कि we say, or the defendant tries to say that the suit is not maintainable, right. So yaad rakhna, just to give you, I just gave you an overview of a written statement. So written statement is basically a reply to the allegations made in the plaint, which may be an admission, which may be a denial, or there may also be silence, which is treated as admission. But the written statement need not be confined to the allegations made in the plaint. There can also be new points like set off, counterclaim, and like we have others discussed to the maintainability of the suit. So that is basically the overview of written statement. So that was the third point. Let's go to the fourth point. The fourth point of the fourth step is appearance and examination of the parties. Okay, this examination is actually an oral examination. Chalo, let's go. Appearance and examination. देखो, actually appearance and examination. ठीक है, this is an oral examination. देखो, appearance is in order 9 and the examination of parties is in order 10, right? So देखो order 9 does not only talk about appearance, it says appearance of parties and the consequences of non-appearance, right? What if the one party appears and the other does not appear, right? If the plaintiff appears, defendant does not appear, we know it can be an ex parte proceedings in which an ex parte decree may be passed, right? Or what if the defendant appears and the plaintiff does not appear? There can be a dismissal of suit, but what if the defendant appears and admits, तो वहां पर डिक्री पास होती है, फिर वहां पर सूट डिसमिस नहीं होता. अगर वो पार्टली एडमिट कर लेता है और पार्टली डिनाई करता है, एडमिटेड पार्ट के लिए डिक्री और जो डिनाइड पार्ट है उसके लिए डिसमिसल हो जाता है, राइट? सो दैट इज ऑल अपीयरेंस. तो अपीयरेंस में हम लोग देखते हैं कि व्हाट इफ one party or both parties do not appear. What are the consequences of that? जैसे मान लो कि if both parties do not appear, order 9 का ही अगर रूल 3 पढ़ोगे तो रूल 2 पढ़ोगे तो रूल 2 ऑर्डर 9 का एकदम क्लियरली बोलता है, रूल 3 कि if both parties do not appear the suit may be dismissed. वहां पर भी may be dismissed ही लिखा है, but there is also provision for restoration of the suit. ऑर्डर 9 के ही रूल 4 में पढ़ोगे कि अगर दोनों में से पार्टी में से दोनों में से कोई भी नहीं आता है, then the suit may be dismissed, but the suit may also be restored under order 9 rule 4, right? तो वो सारी चीजें जो है हम लोग वो कहाँ पढ़ते हैं? अपीयरेंस में, ठीक है? अब अपीयरेंस जब होता है, देखो ऑन द फर्स्ट डे अपीयरेंस में क्या होता है? देयर इज द एग्जामिनेशन, ठीक है? एट द फर्स्ट हियरिंग देयर विल बी एन एग्जामिनेशन. देखो और याद रखना कि ये पर्पस जो होता है, जो एग्जामिनेशन है, इट इज एन ओरल एग्जामिनेशन. एंड व्हाट इज द पर्पस? What is the purpose of this examination? The purpose is actually a dual purpose. दो purpose होते हैं इसके. The first purpose, देखो, purpose of examination. Purpose of examination. Two purpose. The court wants to understand the real nature of the dispute. Right? The language that has been used in order 10 rule 1 is with a matters to elucidate further in the controversy, elucidate controversy in the suit. So वो language you use है, but the language means the court wants to understand the real nature of the dispute, कि actually इनमें problem क्या है. देखो कई बार क्या होगा cases में husband and wife they make a lot of allegations against each other, but the problem is कि are they willing to live together or do they want a divorce, right? आप बहुत सारी चीजें कह सकते हो, हस्बैंड वाइफ हजारों चीजें बोलेंगे, बट पॉइंट क्या है? should they be allowed to live together or should they be granted the decree for divorce? So that will become the issue, right? So वो कैसे कोर्ट को समझ में आएगा? जब तक कोर्ट दोनों पार्टीज को बुला करके और उनका ओरल एग्जामिनेशन नहीं करेगी, कोर्ट विल नॉट अंडरस्टैंड कि what is the real purpose or the real nature of dispute between the parties, right? First thing. The second purpose is, दूसरा पर्पस है इसका कि कोर्ट wants to see is ADR possible, right? ADR is alternative dispute resolution. तो कोर्ट देखती है कि क्या ADR possible है या नहीं है इनके बीच में. तो is alternative dispute resolution possible or not? Is alternative dispute resolution possible? Is ADR possible or not? और जब अगर मान लो कोर्ट को लगता है कि ADR possible है, तो the second question must be which kind of ADR? ठीक है? Which kind of ADR is possible? Because it can be arbitration, it can be conciliation, or it can be mediation, or it can also be judicial settlement. That is section 89 read with order 10 rule 1A of CPC, right? तो वही चीज वहां पर देखनी होती है कि कौन सा पहली चीज कि ADR पॉसिबल है या नहीं. अगर मान लो यहीं पर एडीआर पॉसिबल नहीं हुआ तो कोर्ट एडीआर ऑर्डर भी नहीं करेगी। लेकिन मान लो कि कोर्ट को लगता है कि एडीआर हो सकता है, तब कोर्ट को लगता है कि किस तरह का एडीआर होना चाहिए। नाउ दैट डिपेंड्स अपॉन द नेचर ऑफ द डिस्प्यूट। अगर हस्बैंड वाइफ के बीच में मैटर है तो वहां पर आप आर्बिट्रेशन नहीं ऑर्डर करोगे, वहां पर देयर विल बी इधर कॉन्सिलिएशन और मीडिएशन। द जनरल प्रैक्टिस इज मीडिएशन, बट कभी कभी कॉन्सिलिएशन भी हुआ है, ऐसा भी हुआ है। तो याद रखना द पर्पस ऑफ एग्जामिनेशन। अगर मान लो कि लेट्स से बैंक और उसके एम्प्लॉय में या बैंक और उसके कस्टमर में अगर मान लो प्रॉब्लम है, वहां पर आर्बिट्रेशन इज नॉट गोइंग टू होल्ड, मीडिएशन भी नहीं होगा। वहां पर ज्यादा अच्छा है कि उनसे उनके बीच में कॉन्सिलिएशन हो जाए। तो कॉन्सिलिएशन में कॉन्सिलिएशन का पर्पस ये डिटरमाइन नहीं करना होता कि हु इज रॉन्ग एंड हु इज राइट। द पर्पस ऑफ कॉन्सिलिएशन इज टू हेल्प द पार्टीज रीच अ म्यूचुअली अग्रीड सेटलमेंट। तो दोनों पार्टीज जो है वो अगर कॉन्सिलिएट कर लें अपने डिस्प्यूट्स को, दैट इज द मच मोर डिजायरेबल आउटकम फॉर अ रिलेशनशिप which has to be continued, like a banker and customer relationship must be continued, or a labor union and the management अगर उनका कोई dispute है, it's such a relationship where the relationship needs to continue, like partners में, right? But partners में भी it is based upon mutual trust. वहां पर भी arbitration मत कराओ, even not mediation, it should be conciliation. The parties come to a settlement in the mediation proceedings, in the conciliation proceedings. Sorry. So देखो, this is order 9 and 10. I just give you an overview of order 9 and order 10 की एग्जामिनेशन होता है, राइट? अब देखो यहां तक हम लोग जो पहुंचे हैं, दिस इज द थर्ड स्टेप, सॉरी फोर्थ स्टेप ऑन आवर टाइमलाइन। इट इज द फोर्थ स्टेप, अपीयरेंस एंड एग्जामिनेशन, एंड द नेक्स्ट स्टेप इज फ्रेमिंग ऑफ इश्यूज। ठीक है, नाउ फ्रेमिंग ऑफ इश्यूज, दैट इज आवर नेक्स्ट स्टेप। बट व्हाट डू यू एक्चुअली मीन बाय एन इशू? ठीक है, पहले लेट्स सी व्हाट डू यू एक्चुअली मीन बाय एन इशू। Framing of issues or settlement of issues, they mean the same thing. Both are order 14 or framing of issues. This is order 14. Okay. Now the first question that I put up is, what is an issue, right? What is an issue? And the common sense definition of an issue would be, right, a problem. What is a problem, right? Although that may work in the common sense, but it is not going to work in CPC. So when you are asked the technical definition of an issue, the first thing you must see, देखो, in an issue, what happens is one party affirms or asserts and the other डिनाइज। ठीक है, याद पहले ध्यान सुनना, एक पार्टी कोई assertion कर रही है, affirmation कर रही है, and the other is denying it, right? Let's say I have a phone and someone comes to me and he says this is my phone, right? Suppose this, I have this phone and someone comes to me and says this is my phone, right? What is that person doing? That person is affirming or asserting something, right? That this is my phone. That's an affirmation or that's an assertion. Now I have to reply to his assertion, right? Now देखो, other denies only if I say that this is not your phone. To that person, whoever said to me that this is my phone, I said to him this is not your phone, that will be a denial of his assertion or his affirmation. ठीक है, and देखो, if that person says this is my phone and the denial is going to be this is not your phone, on the basis of this affirmation and this denial, the question that we are going to ask, the question is whether the phone belongs to A. Let's name this person A. This is A saying this is my phone, whether the phone belongs to A, right? अब देखो, इश्यूज अगर कभी भी तुमसे पूछा जाए कि व्हाट इज एन इशू, ऐसा समझना, दिस डेफिनेशन इज इन ऑर्डर 14 रूल 1, फ्रेमिंग ऑफ इश्यूज। इश्यूज अराइज व्हेन अ मटेरियल प्रोपोजिशन ऑफ फैक्ट और लॉ इज अफर्म्ड बाय वन पार्टी एंड डिनाइड बाय द अदर। बिकॉज अगर देखो, one party must affirm it or allege it or assert it and the other party must deny it, because if there is no denial suppose the party admits it, ठीक है. If the party admits it, there will be no issues between the parties, right? देखो मान लो कि वाइफ ने बोला हस्बैंड, अपने हस्बैंड पे एलिगेशन लगाया that the husband has mistreated me and that is why I am entitled to maintenance, right? अब हस्बैंड अगर इस बात को एडमिट कर ले, देयर विल बी नो इश्यूज बिटवीन द हस्बैंड एंड द वाइफ, वहां पर उनमें कुछ होगा ही नहीं. इश्यूज कब अराइज होंगे? व्हेन द हस्बैंड डिनाइज दैट आई हैव नॉट मिसट्रीटेड माय वाइफ एंड देयरफॉर आई एम नॉट गोइंग टू गिव हर एनी काइंड ऑफ मेंटेनेंस. दैट विल बिकम द इशू. डिनायल पर ही इशू बनेगा. इसीलिए इस बात का ध्यान रखना कि इश्यूज अराइज व्हेन वन पार्टी asserts and the other denies, ठीक है. उसके बेसिस पर ही हम लोग इश्यू फ्रेम करते हैं. एंड नाउ इश्यूज एक्चुअली अकॉर्डिंग टू ऑर्डर 14 देयर कैन बी टू काइंड्स ऑफ इश्यूज, इश्यूज ऑफ फैक्ट एंड इश्यूज ऑफ लॉ. बट ऐसा नहीं होता. देयर इज आल्सो अ थर्ड काइंड ऑफ इश्यू व्हिच इज अ मिक्स्ड क्वेश्चन ऑफ फैक्ट एंड लॉ, ठीक है. वो भी हो सकता है. बट जनरली हम लोग यही मानते हैं इश्यूज ऑफ फैक्ट एंड इश्यूज ऑफ लॉ, दैट इज द जनरल रूल इन सीपीसी. तो याद रखना इश्यूज में अब हम लोग कैसे फ्रेम करेंगे. जो भी प्लेंट में असर्शन होती है और एफर्मेशन होती है, वही चीज रिटन स्टेटमेंट में देयर विल बी अ डिनायल, और इट कैन आल्सो बी एन एडमिशन रिप्लाई, क्योंकि हम लोगों ने देखा था कि डब्ल्यूएस में यू कैन रिप्लाई टू इट और यू कैन एडमिट इट. अगर डिनायल हुआ है देखो, तो यहां पर अगर हम लोग इश्यू फ्रेम करने जाएंगे तो हम लोग को क्या करना पड़ेगा, एडमिशन वाला पार्ट हम लोग हटा देते हैं बिकॉज वो इश्यू के लिए जरूरी नहीं होता. प्लेंट में असर्शन हुई है और डब्ल्यूएस में हमारा डिनायल हुआ है. इसी के बेसिस पर द क्वेश्चन विल बी फ्रेम्ड and that will become the issue in that case. And there can be more than one issues, बिल्कुल हो सकते हैं. issue number 1, issue number 2, ज़्यादा नहीं होते, 3-4 मैक्सिमम होते हैं. There have been cases there were 5 and 6, but that is an exceptional case. Generally 1, 2 or 3 issues are involved in one case, ठीक है. तो याद रखना इसीलिए कि issue framing जो है वो हम लोग कब करते हैं, when we have both the parties have given their written submissions and the court has also examined them. देखो यहाँ पर जब कोर्ट का एग्जामिनेशन की हम लोग बात कर रहे थे, कोर्ट के एग्जामिनेशन में हम लोगों ने क्या कहा था, फर्स्ट पार्ट इज कोर्ट वांट्स टू अंडरस्टैंड द रियल नेचर ऑफ द डिस्प्यूट एंड देन द कोर्ट अंडरस्टैंड कि इन लोगों में प्रॉब्लम क्या है. तो प्लेंट में असर्शन, डब्ल्यूएस में डिनायल एंड देन द कोर्ट्स एग्जामिनेशन, ऑल ऑफ दीज थिंग्स दे आर हेल्पफुल फॉर द कोर्ट टू फ्रेम इश्यूज. यहाँ से and then the court's examination, then there will be the issue of issue framing. Why is issue framing important? The issue framing is important because it brings the parties to specific controversies कि okay, what is the problem here, right? तो it gives a direction to the suit कि okay, अभी तक तो कई सारी चीजें कही जा रही थी, बट अब हम लोग इन दोनों चीजें पर फोकस करेंगे. तो दैट इशू गिव्स अ डायरेक्शन टू द ट्रायल. ट्रायल को एक डायरेक्शन देने के लिए हम लोग इशू फ्रेम करते हैं, राइट. नाउ व्हेन द इश्यूज हैव बीन फ्रेम्ड, दिस वाज सेटलमेंट ऑफ इश्यूज. आई थिंक दिस वाज आवर स्टेप नंबर 5. 1 2 3 4 5, right, it was number 5. Then we have number 6, which is trial. Let's go to trial. This was our 5th step. Now let's go to number 6, which is trial. Chalo. Trial or the hearing of the suit. This is under order 18 of CPC. Now trial, याद रखना जो हम लोगों ने इश्यूज में, फ्रेमिंग ऑफ इश्यूज के स्टेज पर जो इश्यूज फ्रेम किए थे, उसी क्वेश्चन का आंसर हम लोग, that the question that we had framed in the issues, what we are going to do with that question. It's not like we just frame the question and leave it at that. No, we have to look for the answers and the process through which we get the answer to the questions framed in the issues, that is a trial, ठीक है. So जो भी क्वेश्चन हम लोगों ने इश्यू में फ्रेम किए थे, उसी का आंसर हम लोग ढूंढते हैं ट्रायल में. Now what happens in a trial? First, the plaintiff gives his evidences in support of his allegations. In support of his allegations. Then the burden of proof shifts to the opposite party, that is the WS, sorry, not the WF, defendant. the defendant has to give evidences in his favor. In his favor. So I'm just giving you a very basic overview. It's not so simple. There are actually many complications in this. The plaintiff has not only to give his evidences, at this stage the defendant can also cross-examine the plaintiff's witnesses. अगर यहाँ पर मान लो witnesses उसने produce किए हैं, तो witnesses का examination in chief वैसे तो यहाँ पर Order 18 का Rule 4 बोलता है recording of evidence it is done on affidavit, examination in chief and even the cross-examination may be done, even re-examination may be done on affidavit. But Order 19 का Rule 1 proviso ऐसे ये भी कहता है कि the court may actually ask someone to appear in person for the cross-examination. So we are not getting into the too much detail because हमारा point जो है पूरा civil suit को देखना है, सिर्फ trial को नहीं देखना है. Trial is basically the proving and disproving the evidences, proving your own evidences and disproving the evidences of the opposite party, right? And both are given the opportunity of being heard and presenting their evidences effectively, right? So that is the whole process of trial. And जो issues में question हुए थे, issues में याद करो अभी थोड़ी देर पहले हम लोगों ने issues frame किए थे, issues में जो भी question हम लोगों ने frame किए थे, उन्हीं questions का आंसर हम लोग उसकी सपोर्ट में प्लेंटिफ अपने एविडेंस देगा और उसके अपोज में डिफेंडेंट अपने देगा, राइट? एंड बोथ ऑफ देम विल बी गिवन द चांस ऑफ आर्ग्यूमेंट्स. कभी कभी कोर्ट दे देती है टू सम अप द केस, कैसे कैसे करना है, ऑल ऑफ दोस थिंग्स. एंड आफ्टर द केस इवन याद रखो, कोर्ट इज नॉट अ पैसिव स्पेक्टेटर, द कोर्ट इज एन एक्टिव पार्टिसिपेंट. एंड कोर्ट, तुम लोगों ने शायद पढ़ा हो 165 ऑफ इंडियन एविडेंस एक्ट, द कोर्ट कैन आस्क एनी क्वेश्चन टू एनी पार्टी एट एनी टाइम. तो द कोर्ट इज नॉट अ पैसिव स्पेक्टेटर. वो प्लेंटिफ से ही क्वेश्चन यहाँ पर पुट अप कर सकती है या फिर वो डिफेंडेंट से यहाँ पर क्वेश्चन पुट अप कर सकती है. इट कैन आल्सो समन एनी डॉक्यूमेंट और थिंग. 165 एविडेंस एक्ट इज क्वाइट कॉम्प्रिहेंसिव इन दैट केस. So after both the parties have been given their opportunity of being heard, then the court, what it does, then there is the judgment and which will be followed by a decree. ठीक है, right? तो कभी कभी हम लोग कहते हैं कि judgment, we use the term judgment, but what do you mean by a judgment, right? It is a decision of the court. Simply speaking, it is a decision of the court. Although this definition is not wrong, right, but a very basic one, right? Decision of the court. But what does the court decide? मतलब डिसीजन तो है कोर्ट का डिसीजन तो बहुत जगह हो सकता है. टेम्पररी इंजंक्शन की एप्लीकेशन कोर्ट ने डिसाइड की है, इवन दैट्स अ डिसीजन. बट व्हाट इज द डिफरेंस बिटवीन टेम्पररी इंजंक्शन एंड जजमेंट देन, इफ बोथ आर डिसीजन ऑफ द कोर्ट? देखो, जजमेंट में एक वर्ड हमारा की वर्ड याद रखना, एडजुडिकेशन, राइट? नाउ यू कैन सी द वर्ड जुडिकेशन इज अगेन हियर, जुडिकेशन यहां पर भी जा रहा है. तो adjudication, what do you mean by the word adjudication? It is the determination of rights and liabilities of the parties. Right? किसका राइट क्या था, क्या वायलेट हुआ और किसने वायलेट किया, उसकी लायबिलिटी क्या है. प्लेंटिफ एंड द डिफेंडेंट बोथ विल बी गिवन देयर स्टेटसेस कि किसकी राइट वायलेट की गई थी, किसकी क्या लायबिलिटी है ऑफ दिस. एंड द डिटर्मिनेशन, द प्रोसेस थ्रू विच, प्रोसेस तो हम लोग देखिए ट्रायल है, जो एंड में जो ये डिटर्मिनेशन के बाद जो डिसीजन आता है, that decision is known as a judgment. So what is a judgment? A judgment is the determination of the rights and liabilities of the parties, right? Now basically अगर हम लोग ऐसे बोलना है कि अगर कि तो judgment में basically कोर्ट ये बोलती है कि which party is wrong and which party is right. So this is oversimplification of a very complicated thing, but that is basically it, कि the court wants to say कि which party is right and which party is wrong. But एक बार याद रखना कि जजमेंट जब भी पास होती है, स्पेशली इन अ सिविल सूट, देयर विल ऑलवेज बी अ डिक्री. ठीक है, इफ द सूट हैज बीन डिक्रीड, दैट इज, ऐसा नहीं कि हमेशा ही होगा. इफ द सूट हैज बीन डिक्रीड, देयर विल बी अ डिक्री. नाउ व्हेन वी हैव द जजमेंट, व्हाई डू वी नीड अ डिक्री देन, राइट? जब कोर्ट ने बोल दिया कि दिस पार्टी इज रॉन्ग एंड दिस पार्टी इज राइट, so मान लो कि वन पार्टी सेज कि द अदर पार्टी हैज टेकन ₹50 lakhs फ्रॉम मी, राइट? and the other party says ki I have not taken rupees 50 lakhs from me. There is an allegation, there is a denial. The question will be framed ki has the one party given rupees 50 lakhs to other party or not? Does he owe the money or not? Right? That issue will be then tried. Suppose the one party succeeds in proving his evidences that I did give rupees 50 lakhs to the other party and he owes me this much, the principal amount as well as the interest, right? Now, that statement that one party is right and the other party is wrong, that will be a judgment. But there is one principle in law which says justice should not only be done, it must be seen to be done, right? सिर्फ judgment pass कर देना sufficient नहीं कि which party is right and which party is wrong. The court must also see to it that one party gives the amount, that 50 lakhs plus interest, to the other party. The court must see the entire process. सिर्फ ये बोल देना it's not sufficient. The court must actually end all the matters. End all the matters between the parties, so that nothing else is left to be decided. अब इंटरेस्ट कितना होगा, राइट? कोर्ट हैज टू कैलकुलेट द इंटरेस्ट की इंटरेस्ट कब से कब तक मिलेगा, कितना मिलेगा. नॉट ओनली दैट, हाउ इज द मनी गोइंग टू बी पेड? देखो 50 लाख आपको देना है, इसे कैसे दोगे? आर यू गोइंग टू पे कैश, आर यू गोइंग टू पे इट बाय चेक, और आर यू गोइंग टू सेल योर प्रॉपर्टी एंड देन पे हिम, और इफ यू डोंट हैव द मनी शुड आई सेंड यू टू जेल? ऑल ऑफ दैट इज given in the decree. How is it going to be done? So decree is the operative part of it. So, although it is not strictly correct to say this, the decree is a part of the judgment, not strictly correct, but yaad rakhna, the judgment will become useless if there is no decree, right? The decree actually tells you what is the exact liability or what is the exact nature of the right of the party. यहाँ पर तो हम लोगों को नहीं बता कि which party is correct and which is wrong, but how much money is owed, how much interest can be given, all of that is part of the decree, right? So I just gave you an overview. Now, lastly, we have, if you come to the timeline, we have the, ये हमारा हो गया judgment and decree. So after judgment and decree has been passed, the one party would like to go for execution. Now, execution is basically the implementation of the decree or the enforcement of the decree, right? That is the part of the execution. So अभी जैसे हम लोगों ने देखा कि the decree is passed. Now the decree has said that this much amount must be given to the other person with interest or anything else. This property must be given to the other person. The person must be transferred. All of those things. Now, the process through which the decree of the court is implemented or enforced, that process is known as execution, right? And it is a very big and complicated process. Again, sections 36 to 74 and order 21 of CPC, they all give you what should I, okay, Arushi, well, judgment and decree तक तो हमारा हो गया, Arushi ma'am. Judgment and decree तक तो हमारा हो गया है. So if you want to end it here, you can end it here. This was our actual topic. मैं थोड़ा सा extra जा रहा था. Okay, so execution. Okay, execution में क्या होता है? Execution is basically the enforcement or the execution of the decree. Now there are different modes of execution. First, you have to file an application for the execution proceedings to start. There is order 21, rule 11, sub rule 2, and in sub rule 2 there are the modes of execution. The modes may include attaching and selling the property, or forcing him to pay, or it can also be that any other mode of execution like he can be arrested and sent to civil prison, right? Not the regular prison, the jail, but the civil prison, or it can also be any other mode. Yaad rakhna, it is a decree holder which decides what kind of, or what is the mode of execution that is going to be practiced in that particular case. Okay? So execution में it can be anything. So वहाँ पर property अगर sale करानी है आपको, suppose पैसा recover करना है and you have to sell it the property. So what is the procedure for the sale? That is also given. Rule 89 to 92 of CPC वो आपको सारी चीजें बताएगा. In fact 67 से ही वो start हो जाता है, but 89 90 में आप जाओगे sale को set aside भी कराया जा सकता है. So all of those provisions must be there in the execution. Right? So this is section 36 to 74 and read with order 21. Right? Okay, Arushi ma'am, that would be it from my side. Okay, so I Uh, Thank you, everyone. I hope the lecture was helpful.